apparently, I've just got a note from my producer in my ear that CNN is reporting that Mark Meadows as well has received a subpoena from Jack Smith, which I think is not shocking, right? If you're subpoenaing Mike Pence, you probably also want to talk to Mark Meadows.
Absolutely. It does suggest, though, since there had been speculation about whether Mark Meadows was cooperating, and that was the reason that DOJ didn't actually go forward with the recommendation. If you remember, he was referred by Congress, and there was speculation that the reason DOJ didn't go forward was because he actually had struck some sort of a deal. And you know that he turned over some documents, but not all documents.
Right.
This would suggest whatever that speculation was, it didn't go anywhere. That you're not issuing a subpoena to someone who's cooperating. Exactly.
It also, I mean, I guess start your engines on lawyers crafting some novel, bespoke form of immunity that applies to chiefs of staff as.
Yes.
As imagined in the constitutional system.
Yes.
Similar somewhere in the constellation next to the vice president who has this very special status.
Right. Maybe he's an aide to the vice president.
Yes, yes, as his status is an aide to the vice president. Right. Exactly. But presumably he's going to try to fight it as well, I would imagine. He can try
and assert executive privilege.
Right.
That is the one where everyone thinks Beryl Howell, who's the chief judge in D.C., has clearly written on that. This may have, in fact, already been decided by the D.C. Circuit under seal in connection with the grand jury matter.
Oh, interesting.
I think that will be a very fast decision.
Okay, that's interesting.
So the Pence thing, though, is more problematic because that could take longer. I mean, it's a novel issue.
It's a novel legal theory.
We can all, say and poo-poo it, but it is something that the courts have to deal with. If I were Jack Smith, what I would do is try and cabin those questions and put him in the grand jury for the things that are unrelated to that claim. So, for instance, you can ask him, Mike Pence, did you think you had won the election? He obviously did not think that. So you can say, why is that? And then tell me about all your conversations with the former president about that. You can ask him about the DOJ plot. You can ask him about the state electors plot. And there's lots of things to put him in on. And
that don't have to do with your ceremonial role as president of the Senate on the day.
Exactly. So you want to try and get him into the grand jury testifying. And you can use the Lindsey Graham decision in the 11th Circuit, which did that kind of split, saying there's a lot of things that he can still testify to that do not relate to speech and debate. So Beryl Howell can sort of fashion that kind of procedure where going to the Supreme Court, or at least to the D.C. Circuit, isn't going to delay everything and get him in the grand jury.
Yeah, just to quickly on that. So Lindsey Graham was subpoenaed by Fani Willis's folks, right?
Exactly.
He raised an objection before in federal court in South Carolina, which is a little weird.
Right. But then it eventually got to the right court.
Ends up in D.C., where he says, look, the Constitution protects speech and debate. Actually, that phrase is in there, right? That speech and debate immunity. And this is a violation of that. The judge said, not really.
Well, the judge actually said...
There's stuff you can talk about that...
Exactly. There's so much that's unrelated to that. So, for instance, you're cajoling state legislators to change the vote. Anything you did on that is not part of the speech and debate clause. So and you're sort of dealing with the Trump campaign, your interactions with them, that's not part of the speech and debate clause. So they carved out
That's interesting.
Many areas.
You sort of cabin off different. I mean, just quickly, I'll give the 10-second version of the Mike Pence constitutional theory, which is a sort of Dick Cheney combination Taco Bell Pizza Hut theory. Right, that you're the vice president because he's in the executive as a vice president, because he's the president of the Senate, he's in the Taco Bell and the Pizza Hut, he's in the executive and the legislative. And when you try to go get him here, he comes over to the legislative, and then you try to go get him there, and he's in the executive, and you can never catch him. That's the short version of it. In terms of the final case, which is the attorney-client privilege piercing here.
Yep.
You guys successfully did that with Manafort.
Exactly.
So it's
in front of the same judge. There is a written opinion that is public. Some of the lawyers who are at the Department of Justice now were working for the special counsel, so they are fully aware of this. It is this exact same issue. Paul Manafort, through counsel, sent a letter to the Department of Justice that said, I do not have any responsive documents. They're all gone. We had a search warrant. We showed that there were documents.
It's the exact same thing.
No, it is exactly the same thing. And just to be clear, we argued crime fraud, but we also argued this isn't even attorney-client privileged. For it to be attorney-client privileged, it has to be a communication where the client, Paul Manafort or Donald Trump, is seeking legal advice. telling somebody to put something in an affidavit or
Right, vouch for my lie is not actually counseling.
Exactly. So we argued it's not attorney-client privilege. It was meant to be public and given to the Department of Justice, and it's crime fraud. So, and the judge bought all of that.
And you won in front of the same judge who will see this Corcoran.
Exactly. This is on all fours, as they say.
All right. Well, Andrew Weissman, thank you very much. That was quite a tour of the legal landscape. Appreciate it.